Government, its regularly scheduled meeting of June 21st, 2018. Here at the beginning of the meeting, we respectfully ask everyone to please silence your phones, tablets, or other electronic devices. There's a limited amount of time available for each of the hearings today, so we want to make sure we respect each appellant's time, each opponent's time, and the board's time as they are asked to be here and hear each of these cases. My name is John Michael. I work for the Metro Codes Department, and I'll be presenting each of the cases to the board today for their consideration. In each of those public hearings, our board reviews the correspondence that's been submitted, whether in support of or opposition to each case. The board also reviews correspondence and recommendations from other government agencies in preparation for today's hearings. And in each of those hearings, staff will present today photographs, site plans, and other documents that comprise the case record for the board's consideration. At the conclusion of the staff's presentation, an appellant will have the opportunity to present his or her case to the board. After the appellant's presentation, the board would hear from many of those wishing to speak in support of the appeal that's being presented. And then if there is in fact opposition present, the opponents would have their opportunity to address the board. After that is completed, the appellant would have the opportunity to come back and give rebuttal testimony if they wish. Under the Board of Zoning Appeals Rules of Procedure, an appellant has 5 minutes to make a presentation to the board if there is no opposition present. For contested cases, both sides have 10 minutes to make their presentations. Again, that's both sides, not every individual present wishing to speak in support of or opposition to a case. Otherwise, we would never, ever leave. In the event that an appellant wishes to save some of their time for rebuttal purposes, they should do so out of that originally allocated 10 minutes. At the conclusion of each hearing, our board will deliberate and then vote on the case that's at issue before the board. The board's vested with the power to act on these cases under the provisions of the Metro Zoning Code, specifically Section 17.40.180. All of the section numbers to which we refer today come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The zoning code was adopted by the Metro Council and became effective on January the 1st of 1998, with many amendments since then. I'll introduce the entire zoning code and make it part of today's record for each of the cases being presented. The Metro Code requires a record of these proceedings, and because of that, it's imperative that anyone wishing to address the board come forward, sit at the front table, and turn on the microphone, introduce yourself by name and address, and then make the desired presentation. No comments from the gallery will be part of the record or will be considered by the board under any circumstances. The Metro Code requires 4 of our 7 board members in order to establish quorum. The code also requires at least 4 affirmative votes in order to grant an appeal. In the event that 5 or more of our board members are present and an appeal fails to receive 4 affirmative votes, then the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days are considered denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to the Chancery Court of Davidson County within 60 days of the hearing date. Additionally, an aggrieved party may file a motion for rehearing within 60 days of the original hearing date, pursuant to the very specific rules and terms under the BZA rules and regulations. After that time elapses, the board's decision becomes final and no further action can be taken. For the appellants in our audience, if your appeal is granted, you are in fact required to obtain the permit for which you've applied. You have 2 years to do so. A permit must be obtained within that 2-year window in order for a board approval to remain valid. After such time as that, you have to start the process all over again. It should also be noted that if any false or misleading testimony is presented to the board, then the board can revoke any approval at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit all the cases have been filed in the proper order today. All appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. Before we jump in with any other particulars, I'd like to make a couple of preliminary announcements with regard to withdrawn and deferred cases from today's docket. The first case that was withdrawn was 2018-219. That case was withdrawn just last night. Case number 2018-221. Deferred to the July 5 BZA meeting. Case number 2018-315, deferred to the July 5 BZA meeting. Case 2018-316, again, deferred to the July 5 meeting. Case 2018-272, deferred to the August 2nd meeting. And finally, the last case on the docket, case 2018-314, deferred to the July 5th meeting. If anyone in the audience is present for one of the cases that I just identified, those cases will not be heard today, and we don't want you to stay if you don't want to stay, since those cases will not be heard. As most of you know, the board utilizes a consent agenda. One board member reviews the record for each case prior to today's hearings and identifies any such cases which meet the criteria for the requested action before the board. If that reviewing board member determines that the testimony in the case would not alter the material facts, then the case is recommended for consent agenda and approval subsequently. We will enter into the record those cases that have been so recommended, and if anyone is here in the audience in opposition to one of the cases identified for consent agenda, just raise your hand and make sure that I see you. We'll remove the case from consent agenda and hear it in its regular order. There are 4 such cases identified for the recommended consent agenda. The first of which is case 2018-266. Mr. Chairman, this was the previously heard matter involving the property at 1512 Dr. D.B. Todd Jr. Boulevard in Council District number 21. Sorry, just flipping to the case. That's 1512 Dr. D.B. Todd Jr. Boulevard. That case is recommended for consent agenda with the condition that the appellant and the planning department agree upon their alternative sidewalk design. The second case recommended for consent agenda is 2018-293 involving the property at 3001 Ned Shelton Road in Council District number 29.
Oh, John Michael, did you call for if there's anyone in opposition?
Apologies. Is there anyone here in opposition to the first case identified for consent agenda, number 266? Seeing none, that case will be recommended for consent. The second, case 2018-293, was recommended for consent agenda conditioned upon meeting the Planning Department's recommendations, namely for dedication of right-of-way. Is there anyone here in opposition to case number 293? Seeing none. The third case recommended for consent agenda is 2018-308, involving the property at 112 Tiger Circle in Council District number 3, a request for a variance from rear setback requirements. Is there anyone here in opposition to case number 308? Seeing none, the fourth and final case recommended for consent agenda is case 2018-328 from Council District number 15, involving the property at 610 McGavick Pike, a request for variance from sky plane and height restrictions. Is there anyone here in opposition to case number 328? Seeing none, Mr. Chairman, that leaves us with 4 items on the proposed consent agenda, cases 266, 293, 308, and 328. We would request a motion at this time.
Okay, those cases have been moved to the consent agenda. Is there a second?
Second.
A motion's been made and properly seconded. Any discussion about the consent agenda? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Consent agenda unanimously passes. John Michael.
For all of our members of the audience who are here on one of those 4 cases that was just passed on consent agenda, you're done. Please see staff as early as Monday in order to pursue the permit for which you've applied. You need not stay for the rest of the hearings today unless you wish to do so. Mr. Chairman, we always like to take an opportunity at the outset of our meetings to recognize the elected officials who are with us, and I do have 2 council members present today.
Yes,
we want to give them an opportunity to address the board here at the front end of the meeting if possible.
Of course.
First, Councilmember Karen Johnson is with us. Councilmember Johnson.
And we think we have long meetings. They had a 7.5-hour meeting that lasted until 1:30. So congratulations. At least we have a budget now. Well done. Council Lady Johnson, welcome back to the BZA, which you used to serve on. So.
Yes, I didn't know that this wasn't on, so now it's on. Yes, Chair Ewing and esteemed members of the board, it was an honor to sit where you are sitting because I learned what I know now and have been an effective council member as a result of that. David, you know that very well, and Alma. First of all, I want to thank Mr. Robin York on case 2018-219. As you know, I was here at the last meeting that we spoke on this, and then you deferred it to this meeting. I'm very happy to hear that he has withdrawn this request. I did want you all to know that I met with him and the neighbors at the property. and we all came to the consensus that the best course of action was a withdrawal. So he did that, I think graciously, because of the concerns that were expressed by the neighbors. He listened to those concerns, and as a result, submitted his withdrawal accordingly. So I want to commend him for doing that, and let you all know on the record that he did take the time out to meet with myself and the neighbors, and is doing the right thing. So that was pleasing to see that today. The other case is on page 10, and that is case, hold on, let me get there. Case 2018-291. I've received a lot of calls, of course. This is someone who has operated a short-term rental without the permits or the necessary permissions to do so. One of the things that this particular short-term rental has created is a safety issue with children who are within the vicinity of this particular home. They play outside a lot. This illegal short-term rental has a lot of cars parked and going in and out, which creates a concern for the neighbors. So one of the reasons why I'm here today, one, because I don't want it approved today, hopefully to get a deferral. The neighbors do have a petition that they want to submit. This is kind of a short notice of them learning that it was an appeal for the illegal short-term rental to be approved for operation. And their fear is that it will be approved today on a temporary basis and their concerns would not be addressed. So before any approval is made, I would like to ask your indulgence in giving me the opportunity to get with the neighbors as well as this owner of this short-term rental. Because I wasn't aware. I don't think they let council members know that they're going to actually convert their home into a short-term rental. But when there are children involved and there are safety issues with regard to the activity with that particular property, we want to take every precaution to make sure that we come to a consensus as to what would be deemed appropriate or not for activity at this particular residence. So that's why I'm here today. It's not anything against the owner. It's just that, as you all know, I'm a council person that believes in collaboration and coming together with everybody to see if we can come up with a win-win for everybody.
How long would you need to have this deferred, the July 5th or the second meeting of July?
I would say because of the holiday, the second meeting in July would be best for me as a councilwoman. Is that something that is manageable, or is that acceptable?
You know, and I can't speak for anyone else, but my thinking is that any penalty that is given to any short-term rental violators takes into account how long it's been since they rented, and so if it were to go another month, then that would certainly be taken into consideration in the case when we decide what the appropriate action would be.
Thank you.
And the other thing, Councilor Johnson, as you know, we accept emails from people about any of these cases, including short-term cases. John Michael, where can they email if they have support or opposition to anything here?
bza@nashville.gov.
Okay, and then
Wow, I'm learning new things today.
and then we will get it. It'll be a part of our packet. So I know people call you, but you could also, and that's good, but you could also encourage them to write us and express their concerns in writing.
I will do just that.
Okay. So
based on the council lady's recommendation, I'll move that we defer case 291 to the second meeting of July.
okay, motion's been made. Is there a second? Motion's been made and properly seconded. Any more discussion?
I think we should hear from the applicant if they're agreeable to defer it. Don't we typically ask the applicant if they would like to defer it?
Well, we can hear from the applicant. Is the applicant here for this particular case?
The applicant on case 291 is
Please-
Martin Rule.
Please come forward and identify yourself for the record and tell us if you are okay with this deferral requested by your council person.
Thank you, Honored Chair, and thank you, Council Member, for your concerns. I am Martin Rule at 288 Clear Lake Drive West, Nashville, Tennessee 37217. And this appeal we put through because we had
I'm sorry, we're just asking you if you are willing to defer it.
well,
We don't
what is
need to
that
hear
exact
this.
date? Because we have July 19th, I believe we will be out of town.
What's the first meeting in
August.
August, John Michael?
Of course, our next meeting is July the 5th, and then our first meeting in August, I believe, is August the 2nd.
That's okay.
I don't know if I would be agreeable to that or not, if we could move forward
Well, why
at
not?
this point, because we did all the proper procedures. We've had the signage in our yard, and we've also sent out all the letters to the corresponding people who had an opportunity to show up here today and express their concerns. We don't present a problem to children in the street. Actually,
Did you rent a home without a permit?
yes, we had
Okay,
listing
well, that's
up.
why you're here.
I understand. We had a
So-
listing
no,
up.
Wait a minute.
And it's still
You
not.
rented a home without a permit. So
We
you were here.
attempted to while we were doing the application process. So if I can explain, I'm sorry to
Well, we're
interrupt.
not here to explain. We're here to talk about a deferral or not.
I understand, but I would prefer to not defer it since we've already had, the 6 months that we've been under penalty, and that we made a mistake by having the listing active when we went to apply, because we thought that the process would be that we could go in and get an application before we had any bookings.
Okay, well,
Then once we found
We're
out that
here to
we,
talk about the first, so board members.
I understand.
But you're testifying that you never rented your home?
No, we had the listings up to book it. We had people staying with us that are missionaries. What we do is trying to, provide a way to use the property when it's not in use for short-term rental, which we saw as an
But if you
opportunity.
charge for it, we have a law that was duly passed by the Metro Council that if you operate a short-term rental, you have to have a license, you have to have a permit, and if you don't, you're in violation, and you have to wait a year before you apply.
understand,
You could
right.
appeal to us, and that's what you're doing.
Right.
Your council person wants to defer this, and that is what we're talking about. You're saying that you shouldn't defer, but you are here because you were in violation of the law, and you are
We understand.
asking us for something set less than a year, which was what you were given
Right.
by the city of Nashville for
Understand.
operating illegally.
Yes, sir.
So the fact that, we can decide whether to defer or not, but, it sounds like you just don't think you should defer because.
No, I'm just trying to fit it in and figure it out, because this is all news to me. No one had contacted, with any opposition. I don't know if there's anyone in opposition at this meeting today. And so,
Again, I'm not going to explain why people aren't here, because I've received a lot of calls.
and I'm so sorry to hear that. And so that's why we do want to have an opportunity to make a meeting with our esteemed council member, whom we love and adore, who does great things for our neighborhood, including the community center. Thank you so
Okay,
much.
so board members.
So, yes, I can defer to August, what was the date again?
Second.
Second,
I'll be happy to do that.
okay?
I just felt it was important to get the applicant on
Okay,
board.
no, absolutely.
Thank you so much.
So we had a motion that was a minute to second, and then second for that, okay. Motion's been amended and properly seconded. Any more discussion?
Thank you.
Seeing none, all those in favor signify by saying aye. Aye, opposed, passes. We'll hear this case August 2nd.
Thank you.
Thank you so
John
much.
Michael.
Mr. Chairman, we're also joined by Councilman Brett Withers from Council District Number 6. Mr. Withers.
Good afternoon, board members. I have written letters to y'all for a couple of cases as I've been learning a little bit more about them. I'll just quickly run through the District 6 items that are on your agenda if I think I can get them all in order. The first one is a sidewalk variance, case 2018-303. This is a sidewalk variance application. There are sidewalks present on that block face. They're not brand new, but they're maybe they have been there for several years at least, but they do not meet all aspects of the sidewalk requirements for collector streets, which South 14th is. However, they are of sufficient width. There is a planting strip present, and the applicant, as I understand it, is requesting neither to construct new sidewalks to the new standards nor to contribute an in lieu fee. Ordinarily, I am of the opinion that anyone opting not to build infrastructure to standard needs to do something. In this rare case, I am amenable to waiving the in lieu fee. There are some topographic constraints on this particular site with regard to a hill and a retaining wall. It's conceivable to me that if they were to have to build it, that it would be actually a little bit, I believe that there's a topographical hardship on this lot that I'm willing to consider it.
So you're saying these are fairly new sidewalks, maybe even built in the Purcell administration?
Perhaps, yeah,
East
exactly.
Nashville area?
Perhaps.
You built a lot of sidewalks in?
Correct, and 14th is a collector street. There is at least a planting strip that is present to help protect pedestrians from the traffic on 14th, which is a hilly street. Now, on the other side of the street, we really do need sidewalks because they are not present there. But in this somewhat rare case, I'm willing to forego an in lieu contribution in recognition of the newness of the sidewalks, but also the topographic constraints of the lot.
Councilmember, I don't know if they're both on this agenda or not, but so if you're going toward the river away from Shelby, this is the one that would be on the right?
It'd be on the
And
right-hand side.
It's got the retaining wall there now.
That's correct.
And is the one on the corner near there, is that on this agenda also?
That one's not on this agenda.
Okay, all right.
Yeah, but that's an area where we really
Okay.
really
Just
do
want to
need
make sure I knew
sidewalks
what
on
you
the
were
other
talking
side.
about, yeah.
So in that particular case, I'm willing to consider the appeal. 2018-262 is a short-term rental for property located at 707 Skyview Drive. The appellant is here. The appellant did reach out to me, which I always appreciate, and let me know her circumstances. This is an owner-occupied short-term rental. The owner let me know that she had moved her home into an LLC for various reasons, and then as the Metro Council was deliberating short-term rental legislation, our current legislation that is in effect, Bill 608, includes a provision that those permits, that one must be a natural person to have a permit. You cannot be a corporation or an LLC. And so she may not have been aware of that at that time. So the appellant is asking for permission to get her permit back since she does continue to live in the home and has moved the property out of the LLC and back into her personal name. And based on those circumstances, I'm amenable to that as well.
Councilmember Withers, may I ask you, I couldn't hear you say what case you were talking about.
I do apologize. I know I'm speaking quickly today. That was case 2018-262.
262?
262 on page 8 for property located at 707 Skyview. I have another case, which is 2018-288 for property located at 508 Russell Street. This also is a short-term rental. This one is also an owner-occupied permit. It's the homeowners are folks that I've had communication with in the community for a couple of years. They've been around in the Edgefield community. So in kind of looking back through it, these are folks, not only do I know that it's an owner-occupied property, but they are concerned about the welfare of the community based on our conversations. And so this appears to be a little bit of a mix-up that they may not have known that we do need permits even for owner-occupied. It's my understanding that they have complied with all requests, and based on those circumstances, there are quite a few letters of support from some of their neighbors, as I understand it. I've also reached out to the Historic Edgefield Neighborhood Association, and they, want laws to be followed, but this is not a case that concerns even the Historic Edgefield Neighborhood Association, which watches their area closely. So based on that, we will extend them grace, and I'm okay with that application as well. And the last one, I actually don't have a lot of information about. That is for case 2018-301 for property located at 2001 Eastland Avenue in the Eastwood neighborhood. This appears, as far as we can tell, to be an owner-occupied property. There is some history of it being taken down and then relisted and taken down and relisted, so I'm not sure what's going on there. I don't have any complaints from neighbors about this one. I don't have a lot of information on the other side, so I trust y'all to make an appropriate judgment for this particular case. And with that, I think I'm being extraordinarily lenient today. I may be just too tired from that budget hearing. But none of these items are things that I particularly want to fight. So.
Okay. Any questions for Councilman Withers? Thank you for being here, and as usual, and we will see you soon.
All right. Thank you.
Mr. Chairman, we are joined once again by Councilmember Karen Johnson, who wishes to address the board.
Okay, welcome back. The floor is still yours.
I apologize. This will be short. I was not aware that there were neighbors here on that particular case. They wanted to be acknowledged as being here because it was made on the record that there was nobody here in opposition. They did take their time to come down here. They know that they're not going to speak on the case because it's been deferred. They asked, what could they do to express their complaints and concerns, and I shared what Mr. Herbert said, Director Herbert said, which was to email bza@nashville.gov. And I've explained to them that they submit any paperwork, et cetera, via that avenue.
And we'll get it.
And you all will get it. So is there anything else that I need to let them know?
But we will just note that there were 2 people in your district that were here against it. So
Thank you so much, Chair.
thank you for being here. Okay.
With that, Mr. Chairman, we're prepared to hear our first docketed case for today. The first one that we'll hear is case number 2018-107. Brett Garrett is the appellant, CH Realty, the owner of the property located at 3818 Logistics Way. The request is for a variance from sidewalk requirements in the IR zoning district to build a warehouse. This is referred to the board as a traditional sidewalk variance case. The site visit here, some period back, the view up and down the street in question, and across the street. You have in your packet the recommendation from the Planning Department with regard to this sidewalk variance, and although this has been docketed previously, there seems to have been some confusion about the party being present for their appeal. If we could invite the appellant forward for case number 107. Is there anyone here in opposition to case number 107? Seeing none, you'll have 5 minutes to make your desired presentation to the board. Just introduce yourself by name and address.
I'm Jimmy Love. I live at
Please press the button.
Sure.
Okay.
I'm Jimmy Love. I live at 315 Lauderdale Road here in town. I'm here on behalf of CH Realty 7 DRG Interchange Center LLC, I believe is the correct entity. I'm one of the developers. I'm with Distribution Realty Group. We have a 118-acre piece of property here that fronts Old Hickory Boulevard and Logistics Way. We're gladly installing the sidewalks on Old Hickory Boulevard, which is obviously a major thoroughfare, and we hope that they'll receive some use. Along Logistics Way, which is a dead-end street, we have a grading issue in which we've had to install a giant retaining wall to make our site work. So on our property, it would be very difficult and potentially impossible to install sidewalks, so we would have to install them in the right-of-way. So we've worked with Metro to get here today.
But I'm reading the Planning Department's recommendation, and they recommend that you build the sidewalk on Old Hickory, and as far as I can read, because they didn't state it, they're saying don't build on Logistics Way and don't pay on Logistics Way.
That's correct.
So, and you're saying you'll do what the Planning Department recommends?
Yes, sir.
Okay, very good. Any questions for the applicant? Okay, thank you for being here. We're going to close the public hearing. Discussion.
I mean, I'll move that we approve the variance for the sidewalk requirement, provided that the applicant meets the recommendation that the Planning Department has laid out, and that is to build a 6-foot grass strip and an 8-foot sidewalk along the property's frontage on Old Hickory Boulevard, tying into adjacent sidewalks as depicted on the site plan that they provided.
Okay.
I will second it.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck. Thank you. John Michael.
Mr. Chairman, we don't have Mr. Michael.
Okay.
He had to run over. Councilman Pulley had sent an email over, and he had need to go pull it because the councilman needed you all to know what that email said.
Okay.
So if we could just take a 5-minute recess
We
until
will take a
Mr. Michael gets
5
back.
Okay, very good.